Michael Smith, why is the Prime Minister on the front page of the newspapers today?
Because of the absence of an explanation for her conduct while she was a partner in the law firm Slater and Gordon, during which time she maintained a sexual relationship with a union official called Bruce Wilson. We now know that she acted for Mr. Wilson independent of her day job, where she was obliged to act in the interests of her client, the Australian Workers' Union. At the heart of this, at the heart of the reason that she is in the public gaze at present, is this course of conduct. Wilson had applied unsuccessfully to the Western Australian Corporate Affairs Commissioner to have him incorporate, which means make a body, incorporate. It's like give personality to an association that Wilson, the boyfriend, purported to head up. It was a sham association. It was a nonsense. It didn't exist. He couldn't get it incorporated by the Commissioner, so he went to his girlfriend, Miss Gillard. She's a lawyer, asked her to help. Had she been acting with proper instructions, had she nothing to hide, one would have imagined that she would have opened a file at the firm and that she would have billed her client for her work. Well, she didn't open a file at the firm. She acted on Mr. Wilson's instructions and prepared a series of bogus rules that purported to represent the rules of a genuine association. It was a sham, it was a nonsense. We know this because we have read in the newspaper of the reports, credible reports, of an investigation conducted by the partners in her firm when her boyfriend's misconduct came to the firm's notice. She was interviewed, the interview was recorded, it was transcribed, and it has been published. Elements of that have been published in the Australian newspaper. So at the heart of it is setting up this bogus sham association for which she didn't open a file at her law firm. We know from police that the existence of this sham entity was unknown to anybody else in the union. It was conducted through a private post office box. There were only two people involved in it, Bruce Wilson and his accomplice, Ralph Blewitt. The Commissioner in Western Australia requires 5 people to be members of an association before it can be incorporated. Well, there were only 2, and there's a range of other legislative provisions that this association breached. But the most offensive of them is right on the piece of paper that bears Julia Gillard's handwriting. The most offensive element of this whole matter is this. The Corporate Affairs Commissioner in Western Australia was deceived. He was deceived by the creation of this false instrument, and that is the certificate that was filled out in part in Julia Gillard's own handwriting, the certificate which asked the Commissioner to incorporate this sham entity. The very first question posed on it is this. This association is formed for the purpose of, and then you fill out the form and you inform the Commissioner why you want it. A lot of people would say Taekwondo Association, table tennis, kids footy, arts. There's a range of reasonable reasons you'd have it. Well, here's what the Commissioner was told. This association is formed for the purpose of development of changes to work to achieve safe workplaces. It sounds an august and lofty ambition, and if it wasn't bultish, it would be quite a reasonable thing, but it was crap. This is a sham entity. We now know from Miss Gillard's own admissions that she actively participated in a deception of the Corporate Affairs Commissioner, because while she participated in filling out this form and creating the bogus rules and objects of the association, she knew, as disclosed in her behaviour, but also most importantly in her departure interview when she was investigated, she described this entity as something vastly different. In fact, I refer from the newspaper directly. When she was interviewed, she said, well, the partner in the law firm who conducted that interview said this, quote, She understood the purpose of the association was to hold re-election funds for union officials. She stated it was referred to as a re-election or slush fund. So what was the Corporate Affairs Commissioner told? The purpose of this association is the development of changes to work to achieve safe workplaces. She told investigators, no, it was a slush fund to hold money for re-election purposes. The Corporate Affairs Commissioner was deceived. As a result of this misleading and deceptive conduct, some of it carried out in the handwriting of the Prime Minister, he duly incorporated the sham association. If it was used to run the tea club and these matters were simply administrative errors, you might be forgiving. But it wasn't. Within weeks of her overt actions in causing this thing, in deceiving the Commissioner and causing this thing to be registered, within weeks she attended the auction by her own admission at which her de facto, her boyfriend, her lover, purchased real property, a house for $230,000. She was there. She tells us she was there. How was that property paid for? Well, by a cheque drawn on the very association incorporated as a result of the deception of the WA Corporate Affairs Commissioner. To me, that is so egregious a course of conduct, so deeply offensive, it ought warrant significant sanction against a lawyer, a person who holds a position of some esteem, some privileges and thus great responsibility in the community. At present, she's not been called to account for it, and I think she must.
Is it not a provision of the Incorporated Association that no monies be paid to members?
Absolutely, absolutely. The legislation in Western Australia is quite clear and specific and concise. It tells you you've got to set out the objects of the proposed incorporated association before the Commissioner considers your application. And it also says, the legislation says this, it must include words to the following effect: no part of the property or income of this association may be distributed directly or indirectly to members. I mean, if you want to set up a trading entity that's going to invoice a company like TEAS for the provision of services, then you set up a trading entity. The Corporations Law provides plenty of opportunity for you to do that. The law in Western Australia was clear. It said you can't trade. If you're proposing to trade, to conduct a business for pecuniary profit, you can't conduct it within this sort of corporate shell. This corporate shell has less burdensome reporting requirements because as a community we want to encourage little structures for the taekwondo organisation, for the table tennis, for little soccer clubs and things like that. We want people to be able to incorporate associations that are genuine like that. But so that it's not abused, the law was really clear and concise, and it set out a range of provisions, all of which this sham entity breached. Nowhere did Ms Gillard seek a resolution of the union that she included the name. It's in her handwriting. She cannot resile from it. The Australian Workers' Union Workplace Reform Association is in her handwriting. On the certificate, the false instrument which deceived the Corporate Affairs Commissioner and led him improperly to incorporate this sham association. You see the agitation in me. I am agitated by it because it's bloody disgraceful. It is truly offensive.
And you were saying that the cheque to buy the house, the cheque which was given to Slater and Gordon, which should have been a bank cheque, was in fact a cheque on this sham entity.
Yes.
Is that what you're saying?
Yes, it is. I have it in my possession. It is a cheque for $67,770 odd drawn on the sham entity and paid into the trust account of Slater and Gordon. Slater and Gordon sent along a conveyancer at the time of settlement and met the vendor's requirement for payment of money so that the transaction would be completed. Now, I don't know if you've ever bought a house, but when your lawyer says, I want a bank cheque, they mean it. I want a bank cheque. This particular law firm must have had a great deal of trust in Wilson, in Bruce Wilson and Ralph Blewitt, because they accepted a cheque drawn on this association the very association that she had set up some weeks, months earlier, and the very association whose rules specifically required a rule that stated, it's set out in the legislation, you have to say this in the rules of your proposed association if you want the Corporate Affairs Commissioner to register it. No part of the income or property of the association may be distributed to members directly or indirectly. How the hell could you buy a house? Gee whiz.
And the Prime Minister has specifically dismissed what is circulating on the internet as something not to be believed. What do you say about that?
There's wisdom in the ages. My grandmother was born in the very early 1900s, and my nan used to say to me when I was a young fella, Michael, you will be judged by the company you keep. And I think that's true nowadays online. You'll be judged by the company you keep. There are plenty of people who blog who have lurid details, who will exaggerate and go on with a lot of crap, make up stories. One particularly prominent blogger even admits that. He's written extensively about this matter, but with a lot of lurid, exaggerated, some deeply personal, deeply offensive detail that I think detracts from the truth, the underlying truth of the forensic dimensions of this matter. Let's be very clear about the seriousness with which this ought be addressed. I am today making specific allegations about the conduct of the Prime Minister. I have used words which I have run by defamation lawyers and criminal lawyers that I believe accurately describe her conduct in deceiving the Corporate Affairs Commissioner in Western Australia such that he would incorporate improperly an association that didn't warrant incorporation. That's a very serious charge, and I appreciate it's a very serious charge. My name is Michael Philip Smith. I wouldn't make that charge if I did not believe completely in the truth of it. But there are lurid websites that don't conduct the exhaustive investigations that I have conducted. Now, I mentioned my grandmother's advice to me, you'll be judged by the company you keep. I engaged Peter Farris QC to advise me about these matters. I take responsibility. I'm not saying that Peter has responsibility for what I say, it's me. But I have a QC's opinion to guide me in what I say and what I think. I have been working with Harry Nowicki, another industrial relations lawyer, since about October last year. I have exhaustively examined Robert Kernahan, the former president of the Australian Workers' Union. I have similarly engaged in some correspondence and have examined in minute detail the affidavit of Ian Walter Cambridge, former Joint National Secretary of the Union. I have copies of the exhibits appended to his affidavit. I've gone through them in chapter and verse. I've engaged probably amongst the preeminent figures in the globe, a forensic handwriting analyst of conspicuous global distinction, Paul Westwood OAM, to advise me in relation to handwriting, etc. I have spoken with Alan Jones on the air, and Alan's external defamation lawyers have examined what I have had to say. Similarly, Ben Fordham on 2GB has afforded me an opportunity to speak in detail about these matters. The company that I keep includes Hedley Thomas. I speak with Hedley about what Hedley is writing at present, other News Limited journalists, various editors of various newspapers around the country. And I value deeply the only asset of real, tangible worth to me that I will carry forward in my life, and that is my reputation. I value it. I would not do or say anything to compromise it. I believe completely in the truth of what I have to say in relation to this matter, and I think that the service of truth and the pursuit of truth is done a great disservice by the lurid, products of imagination that you can find on the internet. Now, I don't think we should go around stomping those people out, but I think that one should exercise some judgment in looking at them and forming one's own view about, is this real? Is it right? Who is this person who is saying it? I don't want to wee in his pocket, but Andrew Bolt is a man whom I know, and Andrew Bolt has, I believe, garnered for himself reputational value far in excess of the value or the worth invested in the mastheads that he represents. In other words, now everybody's got direct access to Andrew Bolt, and they know him. They can see what he has to say, they can look in his eyes, they can judge for themselves the truth or not of what he, as a person, has to say. And I think that that brand-related, if you will, value, the confidence we as human beings have in, say, Andrew Bolt as a person, is much greater than the confidence we now have in these more, abstract or esoteric notions like the masthead, say, Herald Sun or Sydney Morning Herald. We don't know who's behind that. We don't know who the editor of the day is. Is he sick? Who's decided what's going to go in the paper on that particular day? I think in this internet world there are a few adjustments that we need to make as a community, but it is a wonderful thing that we have been given access directly to people who we can now judge much more on much more human terms, on terms that my nan would be much more comfortable with. You can judge them, for example, by the company that they keep. And I think the Prime Minister is right to point out that there have been lurid, often malicious, gross overstatements and exaggerations, some outright lies, on various websites. Judge them for yourself. Don't put everyone in that same basket. Judge them for yourself. Judge what I say on the facts that I have to substantiate what I say.
According to the Prime Minister's biography on the official website of the Parliament of Australia, in 1995 she left Slater and Gordon, stopped being a solicitor, and became the Chief of Staff of John Brumby, a Victorian minister. However, in the newspaper today, there's a suggestion that actually this happened in 1996.
Professor, there's always been a big problem for the Prime Minister. A 6-month period of her employment history that has always been obscured. It dates from the 11th of September 1985, the time at which she was interviewed by the partners in her law firm, and Nick Stein...
95.
Did I say, yeah, 95, I beg your pardon. The 11th of September 1995, she was, we now know through the reports in the Australian, and a man has put his name to, 2 men. Hedley Thomas has written the report, and it has been quoting Nick Stein-Brown, a former partner of Slater and Gordon, who interviewed Miss Gillard on that date. He says, Nick Stein-Brown, the former partner, was there. He says the interview was recorded and transcribed. I would have thought that in the interests of natural justice, a copy would have been provided to the Prime Minister. Certainly I would have thought it would have been retained by the law firm, and the law firm, I think, has a fiduciary obligation to its current shareholders to publicly let us know what it discovered in that transcript of interview with its former employee. Now, it may do that, it may release it, it may not. In any case, Nick Stein-Brown has been quoted publicly. He says that as a result of what the Prime Minister, then Julia Gillard law partner, disclosed, she was asked to resign and her resignation was accepted. That's 11 September 1995. We know she commenced paid employment, next paid employment, on the 3rd of May 1996. To date, the Prime Minister has produced or allowed to be maintained biographical notes that incorrectly have her commencement date with John Brumby in 1995. Now, in that regard, I can point you to an article produced in the Law Society of Victoria Journal, her parliamentary biography, the parliamentary handbook, the National Archives of Australia in the element of that that's associated with Prime Ministers and Prime Ministerial biographical details. All of those 4 are consistent. They all say, falsely, incorrectly, that she commenced with John Brumby in 1995. In fact, it wasn't in 1995. nor was it in January 96 or February or March or April. It wasn't until May of the following year. To date, the Prime Minister has accounted for the 6-month absence in her professional CV by bringing forward the date of her commencement with John Brumby, bringing it forward into 1995. Now, yesterday, on new material release, suddenly we discover, oh, well, no, that's all wrong. The coverage of that 6-month period, in fact, is by extending her time with Slater and Gordon out to May of the following year. They are both wrong. In fact, there was a 6-month period in the middle. The Prime Minister, through these biographical notes released by Slater and Gordon and not repudiated by the Prime Minister, the current story is that she was campaigning for the Senate. I'd like you to point me to the last time you saw a major party candidate for the Senate campaigning anywhere. They don't campaign. They're active internally, jockeying for position on the Senate ticket, position 1 and 2 in the major parties in most states, most likely to get elected, 3 maybe, 4 for a major party, most unusual. But then you don't campaign publicly and say, please give me your vote in the Senate. Remember the Senate, the big tablecloth Senate ticket?
Yes. Who describes it as a leave of absence from the 11th of September?
Andrew Gretsch, the Managing Director of Slater and Gordon, a contemporary of Miss Gillard's in the employ of Slater and Gordon during the time that she was a partner, released, in unusual circumstances, a Med-I release yesterday. And I say unusual because it must have been hasty, because it was released with the subject heading on the internet, on the email, Med-I release, M-E-D-A-I release, small m, and a statement from him, Andrew Gretsch, the Managing Director. He released that yesterday afternoon. Most unusual, I say, for a public company, in that it has an obligation to advise the exchange. It has a continuing disclosure obligation of material matters that may go to affect its reputation. Fiduciary responsibility vests in the Board of Directors. I would have thought this matter was an important reputational matter for the Board of Slater and Gordon to consider in the interests of its current shareholders. It's a public company, but it has to account for the transmission of its history as a partnership into the current corporate body, and for it to have produced on a Sunday, on the day that the Prime Minister had remonstrated publicly with the editor-at-large of The Australian, Paul Kelly, so hastily a document of such import, and to have had it published on that Sunday afternoon, I thought most peculiar. But in any case, that is a matter, as the Prime Minister rightly points out, for Slater and Gordon. Slater and Gordon has released that statement, and that statement is as it is. It says the Prime Minister took a leave of absence.
The former Attorney General of Australia, Robert McClelland, on one occasion at least, called for a royal commission, and he referred to this matter in the Parliament in the context of fraudulent activities in the trade unions of Australia. What do you think should happen now? Should there be, apart from obviously an answer from the Prime Minister, should there be a royal commission? Should it be limited to just this affair, or should it go into the question of the financial arrangements of the trade unions?
Oh, undoubtedly. Undoubtedly there should be a Royal Commission of Inquiry. It is the only way to get to the heart of these matters. I mean, $540,000 went into the account that was established as a result of the false instrument created by the Prime Minister and her participation in deceiving the Corporate Affairs Commissioner in Western Australia. It's not an insignificant amount of money. $540,000 went into it. It was a sham transaction, but it may be emblematic of a range of other things like activities that take place in trade unions. We've seen it in the HSU with Michael Williamson and Craig Thompson. We get an insight into a bit of it in the AWU, and at the heart of it has to be this question: what powers vest in union officials to determine how they spend these large amounts of money in union coffers. And with superannuation money flowing into various superannuation accounts and union officials being routinely appointed as trustees of various superannuation funds, it's a huge amount of money. And I think we owe it to ourselves to examine these sorts of instances of clear malfeasance and better acquaint ourselves with what went on factually, what we learned from it, and how we ought better legislate and regulate ourselves for the future so it doesn't happen again.
In the Ian Cambridge investigation, which I think comes out in his affidavit, did he not refer to other entities being used, other accounts,
Yes,
apart from those relating to the West Australian Incorporated Association?
Yes, he did. There was a range of them, a large number of them. Some of the unions say over $1 million. It is another compelling reason to commission a royal commission of inquiry to get to the heart of what went on. I can't recall a national leader of a union calling for a similar inquiry into his union before. I can't recall it having happened. I think that Ian Cambridge is an honourable man, a man of great integrity, and his push then ought be heeded. But we've got stuff to learn. I mean, we seriously have stuff to learn. The cards will fall where the cards fall in relation to personal responsibility for these matters. That's, people are just going to have to cop it as it is. But as a community, we'll be the better for it.
Thank you, Michael Smith.
It's my pleasure.